Employers nationwide are increasingly using biometric systems for authentication, security purposes, and recording employee work time. According to a survey by Spiceworks, 62% of companies used biometrics in some capacity in the workplace. With the increase in remote work and new workplace procedures in the COVID-19 era, biometric uses have become even more commonplace. However, the increased use of biometrics does not come without risk for employers. In fact, a continued trend of class action lawsuits under the Illinois Biometric Information Privacy Act, or BIPA as it's commonly known, has substantially increased the risk profile for employers collecting and using biometric information. Under BIPA, before an employer collects biometric information, it must provide written notice to each employee whose data is being collected, including the reason for why it's being collected and how long it will be retained. Receive the employee's written release for the biometric collection signed by the employee as a condition of employment, and develop a publicly available written policy that includes a retention schedule and guidelines permanently destroying the biometric information when the initial purpose for collecting it no longer exists. The significant financial exposure employees face under BIPA was further heightened on February 17, 2023, when the Illinois Supreme Court held in Cothran v. White Castle that separate claims accrue each time an employer scans or transmits an individual's biometric identifier or information in violation of BIPA. Suppose, for example, an employee utilizes their fingerprint to clock in and out of work on a typical workday. In this example, BIPA penalties can add up to $2,000 per day per employee, potentially going back as far as 5 years. Thus, the total damages payable could be colossal for companies failing to comply with BIPA. White Castle projected that the damages that could be awarded to the 9,000-strong class could be a staggering $17 billion, which is a devastating financial blow for any organization to bear. What are some steps that employers in Illinois can take to help stay ahead of the class action curve? Illinois employers should develop or review existing written policies regarding the collection, storage, use, transmission, and the destruction of biometric information. Implement policies concerning proper notice to employees about the employer's collection, use, storage, and destruction of that information, and obtain written and signed consent forms from all affected persons. For employers that routinely collect this information from all employees, such as those that use fingerprints or hand scans for timekeeping, consider making the employee's consent a condition of employment, either as part of an offer letter or in onboarding materials. For employers sharing biometric information with any third party, such as a payroll service provider, ensure that the signed authorization addresses the employer's ability to share that information with these business partners. And lastly, establish practices to protect individuals' privacy against improper disclosure of biometric data and identifiers. Looking ahead, the trend of potential class actions is likely to continue. Thus, employers should closely monitor their use of technology and handling of biometric information and take all necessary steps to ensure compliance with BIPA.